While the minister's getting settled, welcome to the Standing Committee on Justice and Human Rights, meeting number 15. For the orders of today, we're going to deal with the standing order, pursuant to Standing Order 108-2, a study of Supplementary Estimate C, votes C5 and C20. And committee members, as you see, there are no actual voting for us to do, as the last supply day was announced for the Monday we get back, which, based on this calendar, these sub-Cs will be deemed reviewed by this committee, but it doesn't mean we cannot question the minister and his staff on those issues. And I'm going to be upfront with everyone in terms of timing. We have the minister for a half an hour. There will be a bell around noon, and a half an hour bell, and then there will be a vote, which normally takes about 10 minutes, which would take us to about, the vote would be over about 22, and they're normally late, so about 1:45. And so, to be honest with you, we're not coming back for 5 minutes. So we have this half hour with the minister. I'm asked the minister to, with his opening statement, and then we'll do one round for sure before the bells start to ring. Yep.
Can we make an opening statement very short then, so
Yes.
it gives more chance to the members of committee to ask the question? Otherwise,
Yep.
we could just go in the lobby and hear the minister talk.
No problem.
Thanks.
So, welcome, Minister MacKay. The floor is yours, and the shorter the better for more questions.
Thank you, Mr. Chair. Colleagues, I will endeavour to be brief in my opening remarks, and should you choose, while the bells are ringing, if you want to go past that, it's entirely up to you.
As chair, is when the bells ring, we adjourn. Thank you.
Pleased to appear before you once again, colleagues. I'm joined by Donald Paragoff, Assistant Deputy Minister Bill Pentney, as well as Luc Robitaille, here to answer your questions on Supplementary Estimate C. And I know, Mr. Chairman, colleagues, that this is of interest to you, and I'm tasked as Attorney General, Minister of Justice, with helping to ensure that our justice system can continue to meet the needs of Canadians so that it can remain relevant, fair, accessible, and that Canadians can have confidence and trust in the system that serves them. Notre gouvernement a fait avancer.
Our government has moved along several priority matters in criminal justice so that Canadians can continue to be proud of our justice system.
Working for them, they need to feel safe in their communities where they live, and if they are victimized, they need to feel confident that the justice system will, in fact, treat them with compassion, dignity, and respect. As you know, we plan to introduce Canada's first federal Victims' Bill of Rights in the House of Commons very soon. This Bill of Rights reflects extensive consultations embarked on this summer, visiting every province and territory, where I met with victims of crime, advocacy organizations, provincial, territorial officials, other organizations, including criminal justice associations and stakeholders from across the country. And I can say that that first-hand, frontline conversation gave me a much better understanding of how we build on our existing criminal law and federal programs. This bill will entrench the rights of victims of crime at the federal level. One of the highlights, I must say, since becoming Minister of Justice was the opportunity to visit several child-youth advocacy centres. I encourage members, if the opportunity arises, to do the same. I'm very heartened to witness the compassionate, caring work done in support of young victims and their families as they navigate an often complex and intimidating system. I'm always heartened to witness the success that we are experiencing at these centres and creating multidisciplinary teams that effectively address the needs of their clients and help them find their way through very difficult events and lessening the trauma that they've experienced. Chair, other issues that we've been tackling include cyberbullying, and as we have unfortunately seen in the cases of Amanda Todd, Rehtaeh Parsons, and others across the country, cyberbullying can have tragic consequences. We need a range of education, awareness, and prevention activities to combat cyberbullying, including a more robust criminal justice response. And with the comprehensive legislation our government has introduced, we intend to provide one. The legislation, Bill C-13, proposes to make it a criminal offence to distribute intimate images without the consent of the person depicted, targeting a serious form of cyberbullying that is not captured currently in the Criminal Code. The Department of Justice is also partnering in the government's recently launched awareness campaign on cyberbullying, which includes television ads that encourage parents and teens to seek the facts out facts and information that this issue is involved in, so they can learn how to use the Internet more safely. Monsieur le Président, notre gouvernement est résolu.
Our government is resolute. It intends to permanently ensure the integrity of our criminal justice system. We have reiterated the commitments that were made in the speech from the throne.
Commons to help ensure that the protection of Canadians is at the forefront of decisions about mentally disordered accused persons who have been found to be not criminally responsible and who pose a heightened risk to public safety. This legislation, Bill C-14, currently before the Senate, will ensure that the safety of the public should be the paramount consideration in the decision-making process, as contemplated in recent jurisprudence. Our government also wants to ensure that our children are better protected against sexual exploitation. And we have just introduced legislation that will ensure that child sex offenders receive tougher sentences. Mr. Chair, our government has always been committed to ensuring the integrity of our criminal justice system, and we reiterate that commitment within the speech from the throne. Other initiatives we continue to work on include legislation to protect service animals, impaired driving, and a response to the recent Supreme Court decision in Bedford. The items that the Department of Justice has submitted to be tabled under Supplementary Estimate C will further our work towards protecting Canadians and ensuring safer streets and communities. Chair, you will note that the Department of Justice's net increase of $3.76 million can be explained as follows. One major area of expenditure is with respect to grants and contributions to enhance the Victims Fund, to expand the reach of the Federal Victims Strategy, especially for child advocacy centres, as previously mentioned, and time-limited operational funding for non-governmental organizations that serve victims. Chair, there was also an increase of $3.78 million to deliver initiatives under the Roadmap for Canada's Linguistic Duality 2013-2018. This roadmap is led by the Department of Heritage and was announced in Budget 2013. Ces initiatives témoignent des efforts.
These initiatives speak to the efforts that have been made by the Department of Justice to put in place a justice system that is increasingly better adapted and accessible to Canadians and their needs, and which guarantees a better access to justice in both official languages.
Here, $3.6 million are for grants and contributions to allow the Department to continue the training component of the Access to Justice in Both Official Languages Fund. Sub-C estimates indicate a reduction of approximately 1.42 as funds being available within the Department's authorities, which represent a transfer of funds to Shared Services Canada as part of an initiative to modernize and streamline information technology systems. To conclude, I thank you and committee members for the invitation and for the important work that you do, and I look forward to your questions.
Merci. Denise, our first questioner is from the Democratic Party, Madame Boivin.
Merci, Monsieur le Président. Puis je...
Thank you very much, Chair. And I am fully aware of the limits of this morning's exercise, taking into account the fact that time allocation motion in the House has an impact in the House, but an impact also on committee work, which is most unfortunate. I've heard the Minister's opening remarks, and this is a very specific supplementary estimates where he comes to talk to us for the umpteenth time about the Charter of Victims, the Victims Charter rather, and about cyberbullying that I'd like to see speeded up. I hope that it will be dealt with in depth at an appropriate time in a committee where we'll have the time to deal with it appropriately. I imagine the Minister will be coming back at some point with a budget. That is the main estimates. I had the honor this week of meeting Chief Carlson, Nide Joe, and Georgina Sidney, who mentioned an agreement between the Yukon and the federal government that deals with justice in the territories. Apparently, there's about $500,000 missing for the full implementation of that program. I'm somebody who likes to speak. I don't like to say things at the last minute. I like to advise the Minister directly and in a forthright manner that I hope this money will be made available. It's something that exists since 2011, and I find it shocking that it's not there right now. What is happening is that elsewhere, Part 17 is being studied, and I know that there is a link between that and supplementary estimates C. So I would like to know what the consequences will be for Section 17 from the Minister. There's an official languages commissioner who came and said that access to justice is uneven in both official languages at the criminal level. Would the Minister be able to perhaps elaborate on Section 17 and the effect that this is going to be having on a release with respect to the Victims Charter? Will the Charter be dealt with per se as an entity in itself, or will it also affect programs that already exist on the ground? Thank you, Chair. Madame Boivin, I certainly appreciate your interest in these matters. You've mentioned the Charter. It's our government's intention to table this bill in the House of Commons during this session. So before June, you mean? Before the end of June? Yeah, I hope. The House Leader, well...
For the House, including the cyberbullying bill that you mentioned, that we hope will receive adequate debate and arrive here in this committee, as you've indicated.
So you still recommit for the cyberbullying to give the opposition ample time to debate, ample days to review the bill?
Yeah, certainly that is our intention. But as I said, we are fighting a very busy schedule, and there is a disproportionate number of bills emanating from the Department of Justice. But this is a priority for us, certainly for me, as it is, I know, for you. And we want to give not only the House, but this committee in particular, ample opportunity to hear from witnesses and to give it proper examination. With respect to the monetary sum of $100,000 that you indicate is somehow not forthcoming for Yukon Victim Services programs?
$500,000.
$500,000.
The Tlingit-Teslin Council, they just need one little push to have this implemented.
Okay, if you will give me the organization at the conclusion of this session,
Will do.
I undertake to look into it by all means.
Excellent, thank you.
Anything else?
Well, he's got his notice. He hasn't addressed the language issue,
Oh, yeah.
though. Are you
Part-
willing
Part
to
17.
to look into maybe opening up a bit Section 17? Is there any openness from your department on that issue?
Well, I should say that I met prior to the release of the report with the Commissioner. He has made some very specific recommendations with respect to increasing access to justice for Canadians, particularly those outside of Quebec and New Brunswick, where language service in both official language remains a challenge. I know I can speak personally for my own province in Nova Scotia, where we do have a significant Acadian population, that this remains a challenge. One of the big challenges, of which you're familiar, is the lack of Francophone judges able to conduct sometimes very sophisticated, complex trials, both civilly and criminal, in French.
But it was interesting because Department Justice officials were telling us that there were sufficient judges. So sometimes I'm wondering who's saying the right thing. Is there sufficient judges? Is it just a question of allocating them the right territories? Or is it because there is a lack of judges?
It's not the number of judges, to be clear. It is, in fact, those with the language skills to conduct without
No, that's
translation.
what I'm saying. Your Department Justice officials who were at our committee were saying that they were, and it's sad that I don't have the quote here, but I can provide it to you, but they definitely answered to a question from my colleague Godin that they were ample bilingual, able judges to hear. It was not a problem because we're addressing Section 17. So it's as if under Section 17 there's no problem, but for the rest of the justice system there is. What the hell?
Yeah, well, as you know, as you've practiced law, Madame Poivin, we don't appoint provincial court judges. I can speak only for the federal judges, of which we are making efforts, and provide training, not only for our own judges, those federally appointed judges, where I would suggest I do agree with my department, particularly federal court judges. We have ample numbers of bilingual judges. I'm speaking to the provincial court level, where the majority of criminal jurisprudence emanates. There is a challenge there. So we have undertaken a program to help provide language training to provincial court judges, particularly those outside Quebec and New Brunswick.
Thank you. Thank you for those questions. Thank you, Ministre. From the Conservative side, Monsieur Gauguin.
Thank you, Minister, for appearing. Thank you for the officials for appearing again. On February 20th, you announced funding for Justice Canada to host an event for National Crime Victims Awareness Week. It will be in April of 2014. And, of course, you were recently in my riding of Moncton River Dieppe at the YWCA, where you made another important justice announcement. And, of course, you know that the YWCA is an important member of our community and they do great work. Could you elaborate on why the funding for these community organizations is so important, Minister?
Thank you very much, Mr. Gauguin. You've been very active in your constituency, and I was appreciative of the opportunity to meet with your local members of the YWCA in Moncton. They're doing a great job raising awareness in and around the community of Moncton and New Brunswick about issues that victims are facing, issues that victims very often run up against, and how they can access programming to help them and help their families. Victims Week, as you noted, this year will be April 6th to 12th, and the theme is taking action, which is something I think we can all agree has to occur. Funding for National Victims of Crime Week is provided through the Victims Fund, which is administered by the Department of Justice. It is a $120 million fund and has been in place since 2006. There is also money available, and I hope to get a further question on the work of the Canadian Child Advocacy Centres. They are also funded separately and do much of the important practical on-the-ground work to help victims, as I mentioned, navigate the system. So awareness is very important. YWCAs and YMCAs do a tremendous job in their communities. They are, of course, very closely associated to the lives of many, many people living in this country, and they are often there to help answer questions, to help guide them through the justice system. YMCA Moncton is a great example of a proactive group with very committed professional individuals, as you know, and I was pleased to have the opportunity to meet them.
Thank you. That's all for me.
Okay. From the Liberal Party, Mr. Casey.
Thank you, Mr. Chair. Mr. Minister, you recently introduced C-26 into the House, and in response to a question period, you referenced an increase in child sexual crimes over the last 2 years. The figures that you cited, were they the Jurastat figures for the period ended March 2012?
I'll have to get back to you. The figures that I have that I believe you're referring to, Mr. Casey, are an increase of 3% over the last calendar year, which is above and beyond the 3% increase over the year before that. So I'm not sure if that came from Jurastat or whether those figures were generated internally by the Department of Justice. I will get you the source.
So C-26 increases penalties for child sexual offenses and other sexual offenses, and in 13 cases, these are, in 13 different sections, these are increases over and above increases that you made in C-10. I expect you're aware of that. So given that you increased penalties in C-10, and your figures indicate that child sexual offenses over the last 2 years have increased, why are you increasing it again? It strikes me that if the goal of increasing them is to have less, that your increases in C-10 failed.
Well, surely, Mr. Casey, you've done more than just read one of the 9 sections of the bill. C-26 goes well beyond just increasing sentences, and by the way, it makes them consecutive. It makes them possible now to be served back to back for separate offenses and separate victims, which I think is an important component of the bill. It also goes further. It also now allows a spouse to be competent and compellable and able to testify. It delves into the area of child pornography, which in and of itself, as we know, is exploitive of children and very harmful in communities. And perhaps one of the more important components is a public safety lead, which allows for greater sharing of information on those who have been convicted of child sex offenses. It allows us now to ensure that some of our allies are also provided with information about convicted child offenders, child sex offenders, who are traveling outside Canada. And perhaps one of the more important, if not controversial, sections refers to public access to high-risk convicted sex offenders. So individuals can now find out if somebody who is a pedophile is living in their neighborhood or near their school.
Do you not agree that stats that show that child sexual offenses have increased in the last 2 years indicate that the increases that you put in C-10 haven't worked?
Well, I'd answer that 2 ways. Firstly, I would say that C-10 would hardly have had effect in the time period that we're looking at. And secondly, and perhaps most importantly, it indicates to me that we have to do more. It indicates very clearly that we have to take more steps towards prevention, more steps as well for deterrence and denunciation. I can think of nothing, and I suspect everybody around this table would agree, that is more offensive or corrosive in a young person's life than to be sexually abused. And we need to condemn that in the strongest terms in our justice system, in our schools. It is abhorrent to think that a country like ours is seeing a 3% increase in child sex offenses. And I intend to do anything in my power to prevent that.
Mr. Minister, several of the tough-on-crime measures brought in by your government have been given a rough ride in the courts, to your chagrin, at least according to your public statements. I understand that within your department there have been some investigations as to what would be the appropriate timing and circumstances in which to invoke the notwithstanding clause. Can you confirm that and share with this committee what is being undertaken with respect to an examination of when to invoke and the circumstances under which to invoke the notwithstanding clause?
I'm not aware of any examination of the invoking of the notwithstanding clause.
So do you deny that there is a process within your department to examine this question?
I'm not aware of any ongoing examination of when to invoke notwithstanding. There's always examination of legislation for purposes of charter compliance. But I've heard no, this is scuttlebutt. This is news to me.
Thank you. There's a private member's bill coming before the House, C-560, dealing with the Divorce Act. Back in 2009, your predecessor, Mr. Nicholson, indicated that the best interests of the child are always paramount. Given that this question is about to come before the House, what are your views on that, sir?
I agree.
If you're comfortable answering the question, I'll allow it. But you did open the door with your opening speech on other legislation, but you didn't mention this particular one. But
yeah, this particular private member's bill will receive, I'm sure, the rigorous examination that all private members' bills receive. The one that you're referencing, I am familiar with. I can tell you, having practiced some family law, as you have in Prince Edward Island, that the long-held legal maxim and the jurisprudence definitely supports that the best interest of the child will remain the primary concern. I see no change in that regard.
The bill proposes to weaken that in favor of parental rights. You realize that?
Yes, I do realize that.
Okay. Thank you.
1 more minute, sir.
Thank you. In your opening statement, you talked about NCR. Recently, 3 of your cabinet colleagues were vocal in their criticism of the Manitoba Criminal Review Board and publicly discussed a case before the board, a specific case. I compliment you, Minister, in that you didn't. Could I have your views on the appropriateness of that?
Well, it was, as you've indicated, a provincial review of a very high-profile case. Let's not beat around the bush. We're talking about the case of Vincent Lee, who murdered Tim McLean in the most horrifying manner imaginable. And the exchange that you're referring to that took place between primarily a member of Parliament from Manitoba, the province where this occurred, I think is a reflection very much of the way many in the community felt upon hearing the news that this individual, some 6 years after having committed that horrific act, was going to be released without conditions into the community. I think that that's a natural reaction, and I think that they were very much speaking out on behalf of what they were hearing from their own constituents. But as you've noted, as Attorney General, as Minister of Justice, I did not delve into the details of what could still find its way back before the courts in some fashion.
Thank you. Those questions? Thank you, Minister. Our next questioner from the Conservative Party is Mr. Decker.
Thank you, Mr. Chair. Minister, you mentioned in your opening statement today that Canadians need to feel that the justice system is working for them and they need to feel safe in their communities. And you've also referenced several justice initiatives, including the cyberbullying bill, C-13, and the Tougher Penalties for Child Sex Predators Act, C-26. Can you tell us a little bit more about those particular measures and how you feel those will help to build confidence in the Canadian justice system?
Well, this bill, as I was just discussing with Mr. Casey, is very much aimed in its intent and purpose to protect children, to be more proactive or forward-leaning, if you will, in certain measures that we hope will empower police, but also send a very strong message that this type of aberrant behavior will not be tolerated and will be prosecuted to the full extent. So requiring those convicted of certain sexual offenses against children will now receive stronger sentences, so subject to minimum, maximum penalties can be served consecutively, back to back. There is also an increase in the penalty provisions as they pertain to violations of certain supervision conditions, either in parole or court-ordered prohibitions. For example, those very prohibitions that are intended to protect a child from having contact with the sex offender, the abuser, frequenting a place where children are often found, be it a schoolyard or swimming pool, and violating those sections that are designed to protect and envelop a child in a protective environment. If those are violated, there are stronger penalties to attach. I mentioned removing the prohibition for a spouse testifying in certain offenses, certain charges like child sex offenses and child pornography, making them competent and compellable before the courts. The house arrest, parole, statutory release, unescorted temporary absence provisions, again, all of those are now viewed as an aggravating circumstance under this legislation. I believe as well our obligations, moral and legal, to share certain information, be it with other agencies like border services or our allies outside of Canada, about the traveling of Canadian convicted sex offenders, is also something that I think this bill will provide greater safety. And finally, establishing a publicly accessible database that will disclose the names of high-risk sex offenders. I believe, again, this is an important tool not only for the police but for the public to protect their loved ones.
Thank you, Mr. Minister. Certainly I hear from my constituents that there is a concern amongst many of them about the justice system being something that they can trust to make sure that the sentences fit the crimes perpetrated. And it's my view that these provisions that you brought forward will help to restore some of their faith in the system. I wonder if you could tell us, in your view, what you think might be the reason that child sex crimes seem to be going up in Canada.
That is a very difficult question to answer, Mr. Deckard, because I can't imagine in any world where this type of offense could be seen as the slightest bit appropriate. Touching a child, touching an innocent person who, in many cases, is relying on the very person, the perpetrator, for protection, is the ultimate breach of trust. Mm-hmm. And we have seen far too many of these cases where it was a family member, mm-hmm. A coach, a religious person, an individual who had greater access to that child, if you will. And why we are seeing an increase in these offenses defies logic. But what I do know, and what I suspect you and others on this committee, and certainly those in the policing community, those who are victims advocates, those who are tasked to protect, fully embrace all efforts to increase our protection of children, to increase the accountability within the justice system when it comes to the treatment of offenders who breach that trust. I believe that is found in Bill C-26. I believe that there are important steps in that direction. Is there more we can do? Yes. I believe there is always more that we can do. And some of that important work is being done, thankfully, across the country by child advocacy workers, victim services. Certainly police, frontline policing is far more attuned. I think of the incredible work that is done by the Canadian Centre for Child Protection in Winnipeg, Manitoba. And, you know, we can touch on the subject of how much more information and offensive information, quite frankly, is now available on the Internet, and the ability to lure children into certain vulnerable positions is also something we're looking at and is contained in the cyberbullying bill. But I think it's incumbent upon all of us to try to do more to protect Canadian children.
Okay, thank you, Minister. Thank you for those questions. Madame Piquet, the floor is yours.
Bonjour, merci, Monsieur le Président.
Thank you, Chair, and thank you, Minister. You have addressed some of the points under Section 17 of the Criminal Code. I would just like us to dig down a little further about them, particularly with respect to the application of Section 17 of the Criminal Code. I have a two-pronged question. When some years ago the bill was adopted, we know that the Senate committee made recommendations to broaden Section 17 of the Criminal Code and to apply it to parole hearings, specifically with respect to the opinion of a judge, the notice given by a judge to access to trial in both official languages of Canada. Do you feel that there should be further attention given to the implementation of this recommendation, that is, access in both official languages at a trial? I turn my mind to resources now. You've spoken about resources in terms of judges. I think about interpreters. What are the resources in terms of interpreters? I see that there is $3.6 million to promote access to justice in both official languages. This fund that is there, well, with the $3.6 million, yes, and also with the roadmap 2013-2018, will this improve the access to justice in both official languages, these two tools?
That I look forward to receiving the report, the important work that's undertaken by this committee on Part 17. I know you're doing a very in-depth study. You mentioned the $3.6 million annually that are part of the roadmap for Canada's official languages. That money, as you know, is very much to address the issues that you're mentioning, to improve access, to ensure that those who find themselves before the court for a variety of reasons will be able to receive service in both official languages, language of their choice. This is in addition to ongoing resources of $9.9 million, which is there annually to help provinces. And again, I come back to Madame Boivin's earlier question about what are we doing at the provincial level to help ensure that judges in the provincial court are given necessary support, in addition to extrajudicial services. So court services for pathonetaries, for property-related searches, anything related to federal contraventions prosecuted under their respective provincial offenses. Again, the federal government bears responsibility in that regard. I want to give you just a couple of examples of investments that I believe are working and achieving the ends that we all seek. The Provincial Court of New Brunswick has a linguistic training program for provincially nominated judges. So the federal government contributes to this project to help complete French legal terminology language training, which is another important nuance here because, as we know, there is a language associated with law that is not often found in common parlance in English or French. So legal language terminology training. Association des juristes d'expression français d'Ontario. Again, this is a fund, a contribution of over $170,000 specific to the province of Ontario to help with French language minority communities. So these programs and many others that I could list that are happening in the territories, that are happening in British Columbia, right across the country. These are federal contributions where we're partnering with provincial or territorial governments and their departments of justice or attorneys general to help further their language requirements. So this will obviously take time. This will obviously require sustained effort and investment. And I might add that there is other languages, particularly in the north, where we have significant Aboriginal languages and a diverse, in fact, a large number of First Nations languages that we are also trying to help provide resources for translation, training, and I might add, as a final point, this also includes those who are signing for the deaf.
But what about the first part of my question about the...
No, thank you very much for your question. Thank you. What I did allow was the minister to finish the answer. What will happen? Thank you. The bells are ringing, so the process for me is to call the meeting. I want to thank the minister and his officials for coming. As you know, the bells are about a half an hour, then there'll be 10 minutes of, by the time we get done, 10 minutes, it will be like 10 to 1 or 5 to 1, so I'm not coming back. But we do expect the minister and his staff to come back for mains, which we look forward to, and then any introduction of any bills that actually get through the House and get to us. But thank you very much for your time.
I look forward. Thank you,
Adjourned.
Mr. Chair.
I'm sending you